Congratulations to both of our two final teams. You're both outstanding. I've heard nothing but good things, and I'm excited to hear all four of you argue. I haven't watched any of the rounds so far, so I'm excited to hear your arguments. I just want to introduce the judges that we'll have on the panel, and then I'll introduce the four of you as well. So our panel this afternoon consists of federal judges across the state of West Virginia. So we have Federal Magistrate Judge Michael Alloy, he's in the Northern District. Federal Magistrate Judge Robert Trumbull, also in the Northern District of West Virginia. And then Federal Magistrate Judge Omar Abulhassan from the Southern District. We also have Federal Bankruptcy Judge Frank Volk. He's in the Southern District of West Virginia. And then Federal District Judge Tom Klee from the Northern District. And Federal District Judge Irene Bricker from the Southern District. So a good cross-section of our judges here across the state in West Virginia. And they are excited to hear this problem. They were talking about the problem and they're excited about it, so I'm sure they're interested in what you all have to say. So our competitors this afternoon, first representing ComGen, we have Jonathan Barsky and Richard Batzler. And then representing Scrap, we have Karen Anderson and Tor Tarantula. I did that wrong, even though I asked. And so the two schools that are represented here are, we're saying these this time, right? Okay, the two schools that are represented here are William and Mary and Yale Law School. So two outstanding law schools. We're excited to have you both in the final. Good luck to all of you.
The door's locked? All rise. Oyez, oyez, oyez. All persons having business before this honorable court are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. The case of Commonwealth Generating Company versus Stop Coal Combustion Residual Ash Ponds will now be heard.
You all be seated. Good afternoon. Are you all prepared to go forward? All right, let's proceed then, please.
Your Honors, and may it please the Court, I am Jonathan Barsky, representing ComGen in today's appeal, along with my co-counsel, Richard Batzler, who will be addressing the FERC issues, while I will be addressing the issues relating to the Clean Water Act. May we please reserve 2 minutes for rebuttal? Thank you. This Court should reverse the ruling of the D.C. District Court, which incorrectly held that the hydrological connection theory provides a valid theory of liability under the Clean Water Act, and further incorrectly held that there was a point source at issue in today's case. Before I proceed to the argument, would the Court like a brief recitation of the facts?
I think we're familiar with the facts. You can go forward. Thank you.
We believe these Clean Water Act issues ultimately come down to the fundamental value of judicial restraint, the idea that the court should interpret the statutes as Congress has written them and should not rewrite them themselves. And so therefore, turning to the first issue, it is our contention that the hydrological connection theory is invalid based on the plain text of the Clean Water Act, and we believe that conclusion is supplemented by relevant legislative history, as well as the constitutional avoidance canon and the interaction with other environmental statutes.
If the statute's as clear as you claim it is, do we need to get to the congressional history?
I don't think so, Your Honor. Our contention is that you can resolve this in the text of the statute alone. Navigable waters are defined in the statute as waters of the United States and territorial seas. And it's important to note what terms are not included in the definition. The statute does not say navigable waters and groundwaters. It does not say navigable waters and hydrologically connected waters. It does not say navigable waters and waters with a significant nexus to navigable waters.
It also doesn't say directly, does it?
Respectfully, we would argue that it does, Your Honor. In Section 1362.11, when Congress defined effluent limitations, the primary regulatory measure that, as the Sixth Circuit noted, is the heart of the Clean Water Act, it used the phrase into navigable waters. And as the Sixth Circuit noted in a pair of recent cases from Kentucky and Tennessee, that term, into, indicates directness. I could pour my water from one bottle into a second bottle, and a second bottle into a third bottle.
Counsel, what about the argument that in this particular case, the seal was broke and the seal created a direct stream rather than just this huge diffuse seepage into the ground, but there was a crack and it was a direct stream that created a fissure and then it flowed into the groundwater. How do you distinguish that on these sets of facts?
I think there it's important, Your Honor, to note that our facts are exactly that, a seepage into groundwater, not into navigable waters. And the groundwater as an intermediary is important, both for the textual reasons I've already noted, and further, the Act specifically does refer to groundwater in other places. For example, in Section 1252, where Congress describes to have the EPA administrator create pollution control programs, they do make that distinction, navigable waters and groundwaters.
So if this went right into a stream, your argument would be different, but because it went into groundwater, you think that's a distinction?
Yes, Your Honor. As the Supreme Court's held in a number of cases, including Rationale versus United States, where Congress uses language in one part of the statute, but omits it in the other, the presumption is that that difference was intentional, and excluding groundwaters, hydrologically connected waters, waters with a significant nexus to waters in the United States, from the definition of navigable waters, Congress made that choice intentionally.
Doesn't that frustrate the purpose of the Clean Water Act then?
Respectfully, no, Your Honor, and I think there's more than one purpose to the statute at issue in today's case. One is certainly that of environmental protection, but as Congress wrote in Section 1251B, the statute also recognizes, preserves, and protects the primary rights of the states to control forms of localized pollution. And that is exactly one of the arguments that was put forward. The Senate, and this is turning to the legislative history, had a recommendation in front of it to regulate groundwater.
So if we're accepting your argument, then I mean, who are we to look to keep arsenic out of the water, whether it seeps or other ways?
Respectfully, I think there are a number of potential solutions, Your Honor.
Tell me.
One statute that's particularly on point is RCRA, the Resource Conservation and Recovery Act, which covers pollution from solid waste. The coal ash in the impoundment is unquestionably solid waste. And if you look specifically to RCRA, this is 42 U.S.C. section 6907A2B. It discusses that the EPA should create guidelines to provide for, quote, protection of the quality of groundwaters and surface waters from leachates. We believe that is the exact sort of pollution at issue in today's case, and therefore is properly governed under RCRA, not the Clean Water Act.
But if the Clean Water Act applies, then RCRA does not?
Respectfully, no, Your Honor. As the Fourth Circuit noted in U.S. versus Waste Industries, RCRA, which was passed after the Clean Water Act, was the loophole closing statute. We believe that Congress omitted protections from these types of groundwaters in the Clean Water Act, and RCRA picks up the slack.
But they're mutually exclusive, though, correct? If covered by one, then not the other.
I'm not sure they have to be mutually exclusive, Your Honor, but I think in this case we believe RCRA, because it has an on-point textual hook for the exact sort of pollution at issue in the Clean Water Act does not. It would be more appropriate for RCRA to govern.
Does the record address that RCRA's even done anything in this situation?
The record does not specifically mention RCRA, no, Your Honor.
Okay.
And there's no claim under RCRA here that it was asserted below, and certainly not before this court.
Correct, Your Honor. I would also note beyond RCRA, there are other statutes that could potentially address this in a more direct fashion. The record does not reflect whether the groundwater is drinkable. If it is, the Federal Safe Water Drinking Act could apply. CERCLA, the Superfund statute, applies to hazardous releases into the environment. Groundwater is certainly part of that. And further, the state limitations on that were originally, as Compton's predecessor in interest noted, were being violated in 2002 when it reported that to the Vandalia Department of Environmental Quality.
Are the definitions of pollutant and other material definitions under the Clean Water Act coextensive with these other statutes that you identify?
I believe they are, Your Honor. And
well,
so,
could you give me an example?
So I think here where we have arsenic leaching from coal ash, in the case of RCRA, that coal ash would be a solid waste. But under the purpose of the Clean Water Act, if this court does think it applies, then the arsenic that's being conveyed from the coal ash would be a pollutant.
Does it trouble you at all that perhaps this impoundment might fail someday? It's obviously going to be a point source at that point when it hits the navigable waters of the United States as it goes out throughout the valley or wherever, that it would be covered at that point, but it's not simply because it's sitting still right now and leaching in through another way.
No, Your Honor. I think that's consistent with what Congress intended when it wrote the statute, giving the states primary responsibilities over these sorts of local matters like groundwater pollution.
But doesn't that discount Congress's intent generally, remedial intent, in enacting the Clean Water Act? Could it have drawn that final line?
I think it could, Your Honor, and to the extent...
But why? What would be the rational reason that Congress would draw that line?
Well, so Congress, we believe in terms of the votes that were taken in both the Senate and the House on similar proposals to regulate hydrologically connected groundwaters because there were concerns of exactly the sort Your Honor noted, that groundwater could carry pollutants to those waters. And they cited two things. One, the primary historic responsibilities of the states to govern land and water use. And second, they believed at the time that it would be just too technologically infeasible to create viable standards in the Clean Water Act for groundwater. And so on those bases, I think that it is a proper construction of the statute. This was an area left to other environmental laws and to the states. Which brings me to my final point.
Well, but are the remedies available, though? I mean, here, Clean Water Act, they ordered that this be corrected, which would be a significant amount of money to do. If we accept the argument that it's not covered by it, are we left without a remedy, or is there a remedy somewhere to straighten this up? Because arsenic's getting into the water. That's not acceptable.
Respectfully, there is a remedy, Your Honor, and RCRA is a good example of this.
And RCRA can order the cleanup?
Pursuant to the coal combustion residual rules that were issued by the EPA under their authority for RCRA, and I believe that's section, the set of regulations in CFR, it's something 27.97, I'm maybe getting the exact number wrong, but it provides a series of remedies under RCRA for violations where there is solid waste pollution, and it is our contention that if not this exact sort of excavation, there are other remedies like construction of a more effective lining and remedial measures with respect to the waters themselves that would still address this form of pollution.
If I could, counsel, Judge Volk had asked you to divine Congress's intent and how they drafted. I'm going to ask you maybe a more difficult question and divine your adverse party's intent. Any idea why a RCRA claim wasn't asserted at the outset?
It's hard for me to say, Your Honor. The record doesn't include anything about Scrap's or intentions as they divine this lawsuit. All we know is that they filed a Clean Water Act claim once they discovered the pollution. Sure,
and then of course they intervened in the FERC proceedings. I guess I'm just curious: are there difference in the remedies available under RCRA compared to the Clean Water Act? Are the district court's ability to order remediation and other things different between the two statutes?
There may be some differences, Your Honor. To the extent we think those differences exist, RCRA would still be the more appropriate statute, which brings me to my final point on this topic.
Just one thing, if RCRA does it, if you say they can enact these remedies, then is FERC the one who addresses the increases to take care of it?
I think FERC is not the only backstop. In addition to RCRA, as I mentioned, there are other statutes. CERCLA in particular is, again, a remedial environmental law designed to promote these sorts of cleanups, and we think that would also be an appropriate vehicle for addressing the sort of release of a hazardous substance into the environment. Now, my final point before I move to the point source question is that of the constitutional avoidance canon, which the Supreme Court particularly highlighted in the Swank opinion versus the Army Corps of Engineers when it struck down the migratory bird rule. And there the Supreme Court noted that its statutory interpretation was heavily influenced by the idea that it wanted to avoid reaching the question of whether Congress has exceeded its powers under the Commerce Clause and struck the rule down largely on that basis. And we believe similarly here where there is a potential for a massive expansion of liability under the Clean Water Act. And this thing that was noted as when the petitions for certiorari were filed in the Maui litigation out of the Ninth Circuit, the state of West Virginia, along with nearly 20 other states, noted that this could be a massive new expansion of liability, not just coal ash impoundments.
You're saying that like it's a bad thing. I mean, what's wrong with clean water?
Because the text of the statute bounds the court's ability to order those sorts of remedies. And the Supreme Court majority held in Swank that it requires a clear statement for such a sweeping expansion of federal authority relative to the current construction of the Clean Water
Isn't
Act.
what you're suggesting really creating a loophole for increased pollutants in the future?
Respectfully, no, Your Honor.
How so?
Our argument would be that there are other environmental statutes that exist to cover this, and to the extent the Clean Water Act has problems, it is for Congress to amend that statute, not this court. Turning to the second issue, that of whether a point source exists in this case, it is again our contention that the text of the statute is not met here, which says that a point source must be a confined, discrete, and discernible conveyance, and no such point source exists in this case.
But the courts have to date very broadly interpreted what a point source is, haven't they?
Yes, Your Honor.
And it seems to me that you're asking us to narrow what the courts have already broadly defined.
Respectfully, no, Your Honor. In turning to the ground relied upon by the trial court here, that of the facility, they're actually, the two circuits to have addressed this question have ruled in our favor. The Fourth Circuit in Sierra Club versus Virginia Electric and Power Company held that a very factually similar coal ash impoundment was not a point source because it was not a conveyance. And looking to the plain meaning of that term, that a conveyance is designed to convey pollutants from one place to another, the coal ash impoundment was very clearly not that example. It's designed to hold pollution in place, not to convey it.
But it didn't.
Here, the design isn't working. Whether we want to call it a construction defect or what, there's still seepage from the seam. And so that case did, in fact, rely heavily on the fact that it was designed, but this is not designed in that fashion. What if this court can come up with an appropriate remedy whereby we limit it simply to this particular impoundment?
I think I would have two responses, Your Honor. One is that I'm not aware of any authority for construction defects transforming a non-point source into a point source. And second, it's again important to note this impoundment does not pollute into navigable waters. It pollutes into groundwater, and the groundwater here is what actually conveys pollutants to navigable waters. And so we freely concede the groundwater here meets the definition of conveyance, but point source is not just a conveyance. It is a discernible, confined, and discrete conveyance. And as the Sixth Circuit recently held in Kentucky Waterways and the Tennessee Valley Authority case, groundwater cannot meet those other terms of the point source definition. It inherently is a diffuse medium. The pollution seeps through the groundwater and is pulled in all directions by gravity. There is no discrete and confined flow in groundwaters like there would be in surface waters.
But there's nothing diffuse about this. I mean, in particular, the Little Green Run impoundment, this is like 300, how deep is it? It's 330 feet deep, right?
Yes, Your Honor.
It's acreage. I mean, it is really an underground container. I mean, what would be the difference if we had a big tank above ground? It's all this concentrated into one place, and I don't know how you don't call that a holding source. That's what it was built for.
I think we have two arguments with respect to the different sources, Your Honor. That in the case of groundwater, it is a conveyance, but it doesn't meet the other terms. With respect to the facility, it may be a confined and discrete location where pollution is stored, but that is not sufficient. To be a point source, it must also be a conveyance.
You're saying that groundwater is a conveyance. It's really gravity and fluid dynamics, isn't it?
Yes, sir.
And if you redefine it in that way, how does that affect your argument?
I think based on the Fifth Circuit's holding in Sierra Club versus Abston, there is some precedent allowing gravitational pull to constitute a point source. But even then, it would still need to meet the other terms, right? Confined, discrete, and discernible. And so even under that interpretation of how groundwater acts, it is our contention that would still not be a point source.
Am I to understand you want us to use a narrow term for this instead of the broad terms or the broad way the courts have interpreted point source in the past? Is that correct?
I don't think that's what we're asking for at all, Your Honor. I think our request is that this court hold scrap to the burden of proving that there is a point source that meets the full definition. Not one word of it, not a few words of it, but the whole definition. Confined, discrete, discernible conveyance. And if they cannot do that, and there is no point source.
In which part do they not, is it your contention that they don't meet?
It is our contention, Your Honor, that the impoundment is not a conveyance, and that the groundwater, while it is a conveyance, is not confined. I see my time has elapsed, Your Honor. May I briefly conclude?
Sure.
And that the groundwater, while it is a conveyance, is not confined, discrete, discernible. And for those reasons, we believe the district court's judgment should be reversed. Thank you, Your Honor.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. My name is Richard Batzler, and along with Mr. Barsky, I'll be representing ComGen, and I'll be specifically addressing the issues stemming from the FERC rate-making proceeding. And this portion of the case is ultimately about the broad rate-making discretion that Congress entrusted FERC in determining the proper rates at which to set, as well as ComGen's constitutional takings rights as a public utility. This court should affirm the decision of the Federal Energy Regulatory Commission because first, its decision was reasonable and is subject to deferential review under the arbitrary and capricious standard, and second, because disallowance of ComGen's rate request would be a taking in violation of the Fifth Amendment.
If we look at the actual findings of the court or the agency, and we look at the fact that it essentially agreed with SCRAP in terms of the effect that its rulings would have, how can we say that that's just and reasonable?
Well, Your Honor,
in other words, in not having a disallowance, and also in not using the matching principle, how can that be just and reasonable on behalf of the agency? It seems to me that it leans more to being arbitrary and capricious in as much as the court had its factual findings, but also agreed with the results that SCRAP had argued without any real discussion of how it came to its conclusion in light of the findings that it made.
I certainly understand your concerns, Your Honor. Ultimately, however, I think the factual findings of FERC went both ways. And under the just and reasonable test that Congress put forward, ultimately FERC is to weigh both interests, and they did here. They certainly looked to the interests of the monitoring of the groundwater site, as well as its point on the corporate structures and the matching principle, but it also looked to the bottom line of ComGen and ComGen's continued financial stability, and it did make a factual finding that there is likely financial jeopardy to this utility if the rates are disallowed.
Now, the financial stability issue, that's usually related to the shareholders of the utility before FERC, correct?
Yes, Your Honor.
In this situation, we're only talking about one shareholder, and that ComGen is a wholly owned subsidiary of its parent company, correct?
Yes, Your Honor, but ultimately the corporate identity of either the utility or the parent company of the utility shouldn't affect the analysis under the just and reasonableness determination.
Well, what's just and reasonable about the consumer getting stuck with the whole cost of your client's mistake that they may have hid for a while and then dumping it on who they sold it to?
And I certainly understand your concern, Your Honor, but I think the equities balance both ways in this case. Because
how do they balance on your client? I'd like to hear that. I haven't seen one, but go ahead.
Well, ultimately, under the just and reasonable standard, the court has taken into significant consideration the bottom line and the ability to continue to operate of the utility. So the ComGen, as a publicly regulated utility under FERC jurisdiction, doesn't get to set its own rates. And it's operating in an economic situation in which it has made significant capital investments and has taken on significant risk in an area in which, and in an industry in which there are often few substitutes. So ultimately, ComGen and its shareholders have taken on a significant burden, and now with this extreme district court judgment, in which they'd be required to move.
Taking on a significant burden that they caused.
Yeah.
They created the burden, so why shouldn't they be responsible for the payment of the burden? Why pass that along to the ratepayers?
Well, Your Honor, I think it's important to note that part of the ability to pass it on is the ability for ComGen's continued financial stability so that it may comply with the district court's judgment and do this environmental remediation. And that's a factor that FERC did cite in its factual findings and its conclusions on this issue.
Well, maybe
Go ahead, I'm sorry.
Maybe we can ask it this way, and I think that it will get to the court's questions. In a factual scenario like this, counsel, where the agency has indicated that there was probably a lack of proper monitoring on behalf of your client, where it's going to take millions of dollars in order to make repairs, if disallowance or if matching isn't appropriate in this particular case under these facts, when would it ever be used? When would either of those ever be used?
Well, Your Honor, under the matching principle, it's our contention that this would qualify because the relevant factor is the date of the district court judgment, which is in 2017. So that district court judgment is within the service, the continued service of ComGen to the rate-paying customers in Vandalia and Franklin. But in any event, FERC did consider all of these factors. They considered the various tests, and ultimately, although the Supreme Court in Hope has held that there is no one test that the court must apply, ultimately it weighed the factors.
Well, answer Judge Berger's question. When would this apply to where answer her question. She stated it better than I can state it, but answer her question.
Certainly. And Your Honor, I think ultimately it would come down to the discretion of FERC. I think FERC is the proper entity in which to make these balancing of the various considerations.
That means we could never disturb their ruling. I understand that they're due certain amount of deference, and we all want to comply with what we should reasonably give them in terms of deference. But this factual scenario seems particularly strong in terms of when disallowance should be used or when they should have given real consideration to the burden versus the benefit. The court made the findings that ultimately it's going to be a windfall to the shareholders and still did not believe either of those should be applied. And again, given the factual scenario, I just want to know what type of case your client would argue it would be applicable in. Either of those would be applicable in.
Your Honor, I think in a case where there was more of an egregious violation, where there was some sort of intentional discharge.
Or where someone died from arsenic in the water, maybe.
Well, Your Honor, I think ultimately what the role of this court is, and you spoke to the role of this court, and you're correct that it's not that this court is just to accept whatever decision FERC ultimately came to. But ultimately, as the State Farm case in the 1980s by the Supreme Court held, the court is to look and make sure the factors were considered and that they were reasonably explained and that there's a rational connection between the conclusions.
Well, that seems to be the problem. I think the fact that there's inconsistent findings and then a holding without any real explanation as to why they came to the conclusion that they did. And I think that's what we're trying to figure out here is that why should we support FERC's decision without a reasonable explanation as to and justification for their decision?
Because, Your Honor, below, SCRAP did not contest the findings of the impact to ComGen's bottom line. There's no indication in the record that SCRAP opposed the finding that the impact of allowing FERC to bear the full cost of this significant judgment would reduce its return on equity from 10% to 3.2 to 3.6%. That's nearly a 70% increase. And ultimately, that 2016 rate order of 10% was based on FERC's considering of both of these factors. And it's important to recognize that, yes, there are certainly public interest factors that are essential for FERC to consider, but it also must consider the interest of the utility. And that interest has been held to include the ability to pay dividends, the ability to continue to have investments, to continue to provide power and comply with environmental judgments.
Is that really an issue here given the relationship between ComGen and its parent company?
Your Honor, again, I don't think the corporate identities of the parties should factor in, and this court should discriminate based on various corporate identities. These are legally distinct. And
but isn't part of it the ability to retain market or access to the market under these circumstances? And if you reduce their rates and their profit margins, in essence, how does it come to play with a wholly owned subsidiary of CE?
Your Honor, I can't, from the record, forecast the future and what actions CE would take in response to the full cost of this judgment, but what I can point to is the record in which they found a significant likelihood of financial jeopardy if this rate order were to be passed through. And I think it's also important to turn to the constitutional point, because since the 19th century, the Supreme Court has recognized that in the public utility context, there is a Fifth Amendment takings right. When the government is setting the rates, is setting the level of profit at which this utility can earn, there is a right to rates that aren't unduly confiscatory. And ultimately, in making that decision,
What was the explanation? What was the explanation, tell me again, by FERC as to why that rather abstract and extraordinary constitutional principle should counter against factual findings that seem to indicate there is significant fault by the utility?
Your Honor, because the constitutional principle is inextricably entwined with the concept of the continued financial stability of the utility. And that's the fundamental principle here, and that is what is counterbalancing some of the public interests. But again, the public interests are still present in FERC's decision, because FERC's decision to not put this company that's providing power to Vandalia and Franklin into financial jeopardy is serving the ratepayers of Vandalia and Franklin. It's serving the ability of ComGen to react to expansions in the market and also to comply with these environmental cleanup costs, which the district court has ordered.
But was that part of the mix? Was that constitutional analysis part of the mix, or did it just basically come in and swamp everything else, including the fact that ComGen did not properly monitor what was going on in the groundwater?
Your Honor, we only have a few short pages of the record before us today, but I think regardless of, I think ultimately the constitutional judgment is based on this finding of financial incentives and the issue of balancing the interests of the ratepayers with the interests of the utility. So ultimately, that constitutional finding is a concern of FERC and of this court, we would submit. But ultimately, the fundamental issues, the fundamental balancing between $2 to $3 per month over a 10-year period so that...
If we adopt your position, though, aren't we setting a precedent that says that other utilities can be reckless in their conduct, cause these kind of pollutants to go out, and then don't worry about it? We're going to let the ratepayers bail you out when that happens?
No, Your Honor, because in any future case, the utility will still have to go before FERC, which is the federal entity entrusted by Congress.
That goes back to Judge Berger. When is it ever going to be that the utility bears the burden of its conduct and not the ratepayers?
In a factual situation, perhaps different from this. Perhaps there might be an intentional violation. Perhaps there might be a worse situation. But ultimately, FERC determined that based on the financial interests at stake, based on balancing the interests of the utility with the interests of the ratepayers and the ability to comply with these environmental judgments, that this was the proper balance to strike. And in reviewing that decision, this court isn't to determine whether that decision was the best, but just whether it was arbitrary and capricious.
Well, that's where you've missed it. They haven't hit any balance, and that's what's so arbitrary about it, and they've said it in their own words. They've acknowledged that your people have created this problem, that someone else is going to pay for it, and they've created it in a long time. And they made the argument that there should be some sharing of burden if they come down with a different decision. I mean, that's what feels so arbitrary about it. And, I mean, if we accept your argument, there's never going to be any deterrent for these companies to continue to do what they have. Why would they? They can always pass it on. I'm sorry.
At least pass it on, or maybe share the cost. I mean, why isn't should some of the cost at least be allocated to the shareholders as opposed to being passed on to the ultimate consumers?
I see my time has expired. May I briefly respond?
Yes, thank you.
Ultimately, Your Honors, this judgment is about striking the proper balance. And the entity responsible for striking that balance between the $2 to $3 cost to ratepayers to keep the lights on with the utility's ongoing financial success is one that the Congress has delegated expressly to FERC, and this court should defer to that decision. Thank you.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. My name is Karen Anderson, and I represent Stop Coal Combustion Residual Ash Ponds, or SCRAP, and I'll be addressing the Clean Water Act issues before my co-counsel, Tor Tarantula, addresses the FERC order. With the Court's permission, we would like to reserve 3 minutes of our time for rebuttal. Thank you. Your Honors, this Court should uphold the District Court's ruling, which correctly interpreted the Clean Water Act as a comprehensive, strict liability statute not to be weakened by the jurisdictional loopholes that ComGen has proposed.
But they're saying there isn't a jurisdictional loophole, that in fact, or I want to get the an acronym right, but anyway, there's another agency that was given a specific responsibility for coal ash ponds. I mean, is that correct?
Your Honor, it's correct that RCRA is another federal
Yes.
statute that does impose more specific requirements for the storage of this type of solid
So why
waste.
should we be looking at anything else when Congress has already said RCRA deals with coal ash ponds? I mean, that's about as direct as can be, isn't it?
Your Honor, it is correct that RCRA deals with coal ash impoundments, and it imposes requirements about things like the strength of the embankments needed for the impoundment, or the type of liner that needs to be installed, or the routine groundwater monitoring, which failed in this case. But RCRA and the Clean Water Act, as opposing counsel conceded, are not mutually exclusive statutes. Rather, they're mutually reinforcing. And here, while we have RCRA requirements for the proper storage of the coal ash, once that liner fails and there's a discharge to surface waters, the Clean Water Act then does find ComGen both liable and accountable for its pollution of the Fish Creek and Vandalia rivers. And I think that's
To the text that supports that.
the text of the statute, Your Honor.
The text of the Clean Water Act, where you say that this failure in the weld and the seepage then becomes covered by the Clean Water Act as opposed to RCRA.
Your Honor, the broad language of the Clean Water Act finds ComGen liable for discharge of pollutants to navigable waters from a point source. And we believe that both of those inquiries are met, both because the presence of connected groundwater as a conduit doesn't break that to-from pathway, and because the Little Green Run impoundment, and especially its discrete fissure, is a point source.
I think your position, you may be skipping part of the equation. We have, from your perspective, make sure I get the terminology right. We've got a point source, and then you mentioned surface water, but there's an intermediary between those, being the groundwater here, correct?
That's correct. There is an intermediary, Your Honor.
And groundwater is not a point source. Is that correct?
That's correct, Your Honor. It's not our contention in this case that groundwater itself is a navigable water, nor a point source. But as Justice Berger mentioned, the statute doesn't include the word directly. There's no direct discharge requirement. And so here, since we have a point source, as I'll address in a few minutes, and we also have navigable waters.
Can a coal ash pond be a point source? I mean, you're making that assumption that it is.
Yes, Your Honor. This coal ash impoundment is a point source.
Well, you're making that assumption, is it?
It is, because as you heard from opposing counsel, the Clean Water Act requires a point source to have 4 elements. It has to be a conveyance, and that conveyance has to be discernible, confined, and discrete. Here, the Little Green Run impoundment is a conveyance. It collects coal ash, channels its arsenic leachate, and creates immense pressure through a hydraulic head that conveys that arsenic leachate out through the discrete fissure. And we also know, in addition to it being a conveyance, that it's also discernible because the Vandalia Department of Environmental Quality determined the precise pollution pathway from the impoundment to the navigable waters. We also know it's confined and discrete because we can pinpoint the exact spot, the precise pathway of this conveyance out of the impoundment, and it's in the faulty seam in the downstream toe of the west embankment.
Does intent matter, though?
Your Honor?
The coal ash impoundment was not intended to be a conveyance. Would you at least agree with that?
Yes, Your Honor. I would agree that it was not intended to be a conveyance, but the intent...
I understand your position is it becomes one because of the seepage, but does intent matter? Did ComGen have to intend for it to become a conveyance? Or simply, let's assume, best case scenario from ComGen's perspective, it's just a negligent seal that busts and starts to leak. But I'm struggling with getting to the point where this coal ash pond becomes a conveyance because a subcontractor came on property and did a bad job.
Your Honor, the intent is not relevant here because the Clean Water Act is a strict liability statute. And there's a case from the 10th Circuit, U.S. versus Earth Sciences, that's been cited in many, many circuits over time, which stands for the proposition that the point source category embraces the broadest possible definition of any identifiable conveyance. And the facts of that case are helpful here because it dealt with a pile of gold ore on top of a plastic membrane that was supposed to be keeping leachate from going anywhere and wasn't at that time intended to ever function as a point source. But when that membrane started failing, and I quote, whether from a fissure or some other failure, that's when it became a point source. And so the 10th Circuit upheld Clean Water Act liability in that case. And we also see other courts similarly classifying similar facilities to the Little Green Run impoundment as point sources. And going back to the text, not only does it meet all 4 definitional requirements, but the Clean Water Act also enumerates several examples of point sources, one of which is a container, and the other is a discrete fissure. And the Little Green Run impoundment is a container with a discrete fissure. And moreover, it's highly distinct from all of the non-point sources of pollution, which Congress did leave to the states. And those are things like, one classic example is roadway residue that comes from the tailpipes of thousands of cars, or agricultural runoff over a large area coming from many different sources, following many different pathways that can't possibly be traced back because it's not confined, it's not discrete. But that's not the case with the Little Green Run impoundment,
So
where we
would
do
your argument
know.
be different if the whole sheet that's in there, if it was just the seepage came generally into the groundwater rather than at one place? Would that change your argument? Are you following me? If it just seeped in throughout rather than one direct way?
Your Honor, our position is that the impoundment, even if it's over a large area and seeping generally, could still be a point source. And there are several courts that have found that sort of seepage to constitute a point source, holding sediment basins, ponds, other forms of lagoons to be point sources. But we think the case is even stronger here, that this particular impoundment is a point source because of the discrete fissure. And the district court performed.
Have you really determined that that is the source of the arsenic? I mean, this problem has existed since 2006 or 2007, but yet arsenic levels were not elevated until 2017. So have you really determined that it comes from this particular location?
Yes, Your Honor, we have. And ComGen has not disputed on appeal that the Little Green Run impoundment is the sole source of this arsenic pollution. And had they been monitoring appropriately, it probably would have been detected earlier, but instead it took citizen scientists identifying this pollution in the surface waters and then bringing a citizen suit under the Clean Water Act.
Let me ask you a question. Don't you think the drafters of the statute intended for a point source to be something that the polluter could readily identify and understand that that may be something that dumps materials into the navigable waters? I mean, those objective criteria, you sit there and you think, Congress almost wanted to embed in the statute an understanding by this polluter, okay, I'm setting this up to get it into the navigable waters. The seepage, fluid dynamics, gravity, what have you, could have sent these materials in an entirely different direction, but they just happened to send them toward the navigable waters. Do you think Congress really meant for that type of unpredictability to carry the day?
Your Honor, I think it's correct to say that typically in the best of worlds, both regulated industry and state agencies are able to identify in advance what is going to constitute a point source and what isn't. But the Clean Water Act is nevertheless a strict liability statute that does hold ComGen liable because these pollutants did reach navigable waters through the connected groundwater. And I think that going back to Congress's intent, while, as you heard from opposing counsel, they did exclude isolated groundwater from the statute and identified cooperative federalism as an important purpose of the statute, the overarching purpose of the statute was to completely eliminate all pollutant discharge into navigable waters by 1985. And Senator Muskie, one of the lead authors of the Clean Water Act, himself said that the discharge covered by the Clean Water Act includes both, quote, direct and indirect discharges into the navigable waters.
But we really can't properly rely on the statements of one individual to discern an intent by the entire body, can we?
No, Your Honor, but I think it helps illuminate some of the other textual provisions of the Clean Water Act, the strict liability, the way that it was broadly drafted to encompass a comprehensive range of types of pollutants that can reach navigable waters.
I want to go back to something that was brought up in the beginning to help me understand this better. Under RCRA, I mean, first of all, why didn't you pursue that as a remedy? And if you did pursue it, would you have the remedies available to you that you do under the Clean Water Act? I mean, they're just saying you're in the wrong place.
Your Honor, the reason
under the wrong act. Go ahead.
Your Honor, the reason for bringing this suit under the Clean Water Act is that that was the injury that was suffered by members of SCRAP. It was pollution to navigable waters, and that's what the Clean Water Act covers.
So RCRA doesn't give that? RCRA doesn't give you?
RCRA can provide some remedies, Your Honor, for failure to comply with its regulations, but not the kind of excavation of the coal ash impoundment that's necessary here. And that's because the EPA has classified coal ash as a non-hazardous substance under RCRA, and it is classified as a solid waste, so there are some protections that can apply, and that's why, for example, ComGen needed to install the liner in the first place. That's a RCRA regulation.
RCRA couldn't order them to dig this all up and make it right?
Complete closure of a site, Your Honor, can be a remedy ordered when it's a hazardous waste, but this has been classified as a non-hazardous solid waste. And that's the same reason why CERCLA can't apply, because it's been classified as non-hazardous, even though clearly arsenic pollution to the navigable waters is a problem.
What role does the state have in this regulatory scheme?
Yes, Your Honor. Vandalia, the state of Vandalia, does implement both Clean Water Act permits and RCRA permits, but the citizen suit provision isn't blocked by any sort of collateral estoppel or diligent prosecution objection. Citizens can always bring a suit when one of those violations is found, and here the record is silent as to what the state of Vandalia's position is in this matter, so that's not a barrier here in our case.
Well, and I think that my concern, and based on what Judge Alloy had just asked you, is you have options available to you that wouldn't require this court to plow new ground under the Clean Water Act, because I think you're asking us to find that this coal ash pond is a point source, and I think that gets us out maybe a little over our skis. Can you calm my nerves down on that respect? I think you have other remedies, other vehicles available to you. I'm just curious as to why this court has to say the Clean Water Act applies here. This is a point source discharge, all those things that would be relatively new in this jurisdiction when there are other paths that may have gotten you the end result, which presumably is no more arsenic in the water.
Yes, Your Honor. I'll first go to some case law from other circuits that supports the district court's ruling, and then I'll turn to your question about appropriate remedies. So on the connected groundwater issue, most courts do agree that groundwater with a hydrological connection to surface water, as we have here, does fall under the Clean Water Act. The Fourth Circuit in Upstate Forever and the Ninth Circuit in Hawaii Wildlife Fund both said so explicitly. And the Second and Tenth Circuits in 3 different cases in the Second Circuit, 2 different cases in the Tenth Circuit, similarly found that discharge through an intermediary can still trigger Clean Water Act liability. And on the specific issue of hydrologically connected groundwater, we have support from district courts in the 1st, 3rd, 8th, and 11th circuits. And on the point source issue, we do have both the 5th and 9th circuit finding that basins where defendants initially channeled or collected pollutants, as we have here, do qualify as point sources, and similarly support from district courts in the 4th, 7th, 8th, and 11th circuits about similar types of sediment basins, impoundments, ponds, classifying as point sources. And on the issue of appropriate remedies, the RCRA remedies simply aren't adequate here because of the nature of the pollution reaching surface waters, and these statutes are mutually reinforcing. In a case, U.S. versus Dean, the 6th Circuit, for example, that dealt with the operator of a metal factory that was dumping hazardous waste into a lagoon, and that operator tried to argue to the court that he couldn't be found liable for both RCRA and the Clean Water Act at the same time, and the 6th Court dismissed that claim, saying that while RCRA regulations do apply to things like the strength of the embankment, the frequency of inspections, the design of the liner, as soon as you had that discharge of pollutants to navigable waters, Clean Water Act liability was triggered. And so that's why in this case, that's why in this case the Clean Water Act can and actually must still apply, given the undisputed fact that the Little Green Run impoundment here is acting as a point source through its discrete fissure, channeling arsenic to surface water, and that's a to-from pathway that meets the statute. And that's why we urge this court to affirm the district court's ruling. Thank you.
Good afternoon, Your Honors, and may it please the Court. I'm Tor Tarantula representing SCRAP. I'll be addressing the FERC rate order, beginning with the issue under the Administrative Procedure Act and concluding with the issue under the Takings Clause of the Fifth Amendment. Under the Administrative Procedure Act and Supreme Court precedent, FERC was required to provide this court with a detailed accounting and explanation of its reasoning that connects the facts it found to the conclusions that it made. But instead, What they've given this court is a black box. And for that reason, all we're asking is that you remand to the commission for a more detailed factual record and a more reasoned explanation of its conclusion.
Aren't we just looking at a substantial evidence standard review here?
That's right, Your Honor.
And I have long abhorred that phrase because it sounds weightier than it is, at least in my mind, this notion of substantial evidence. But if FERC, in its order, offers a reason for why it concluded the way it did, are we not bound to affirm that order?
Well, this brings me to the first point, which is that the reasons that FERC offers has to be sufficiently explained, and the second point being that they have to be supported by sufficient evidence, which they weren't here. So my opposing counsel suggested that the one real factual finding that supports FERC's decision was that ComGen's financial integrity would be implicated, but that wasn't actually a factual finding, it was a conclusion. And the commission never considered all of the facts that it needed to consider in order to reach that conclusion. So as the Chief Justice's question to my opposing counsel indicated, the 4 facts that they found, and this is at page 11 of the record, were that the weld in the impounds liner was incompetently done. Second, that ComGen failed to properly monitor the effectiveness of the liner. Third, that proper monitoring would likely have detected the seepage earlier. And fourth, that passing along the cost to the ratepayers would be a windfall to ComGen's investors. And really the only rationales other than the financial integrity issue that FERC detailed were unsupported by any sort of connection between these facts and the conclusions. And the first rationale was this rationale of environmental protection. And you heard opposing counsel suggest a potential explanation for this, but I just want to remind the court that in Overton Park, the Supreme Court said that post hoc rationales offered in the course of litigation are not to be credited. What's important is are the reasons that the agency set down on the record and how those reasons were drawn from the facts that it found.
You know, it seems to me, pardon me.
No, go ahead, please.
You have this grand bargain that's struck between the ratepayers and the potential polluters, those who are providing the energy, and I suppose Congress or the legislative body's intermediary. It seems perfectly reasonable to put the cost of environmental compliance on ratepayers. Ratepayers don't want dirty water, unsafe water. Why wasn't that just what occurred here?
Well, Your Honor, the rationale really that I think comports more with this court's findings is that in order to deter bad actions, such as decisions that would lead to environmental liability and substantial costs, as happened here, is that the company should be required to absorb those costs. Otherwise, there's really no incentive for them to avoid them in the future.
Isn't it quite the contrary? If in fact they can have some reliance on being able to recover those costs, they'd be more inclined to fix environmental issues earlier than as opposed to later?
Well, this court actually found somewhat of the opposite reasoning in Iroquois Gas, for example, and in Mountain States. It suggested that companies might actually be over-incentivized to avoid things that might benefit the ratepayers. But in this case, I mean, the broader issue is that FERC necessarily,
but isn't it also commonplace that environmental cleanup issues, the cost of that is often and most generally passed on to the ratepayers?
In cases where they predictably and legitimately stemmed from an action or a choice that had an ex ante or prospect of benefiting the ratepayers, or where there was a reasonable expectation that, for example, maybe cutting costs in one area that would increase environmental risk was done for the benefit of the ratepayers. And we just don't have that case here. In fact, as some questions to my opposing counsel indicated, what FERC actually found was that the company failed to properly monitor its compliance with the state's remedial plan, and if they had done so, they likely would have found the leakage much sooner and probably would have avoided the litigation costs that we see here.
But what about the argument, at least, that they make that you're going to put them out of business if you require them to be responsible for the whole cost, and that's the worst thing that can happen for
and
the
deter
consumer.
other similar businesses from coming to the area.
And if I could make it a trio on top of that, we're not, at the end of the day, we're not just talking about impact on bottom lines of ComGen or its parent. At the end of the day, someone has to provide electricity to the folks at the other end. And I think if you combine the three judges' questions, we kind of follow that chain, and ultimately you're going to have neighborhoods and cities without power if the system doesn't work the way it's set up.
Your Honor, I think these questions get to the central point, which is that there are potentially valid arguments on both sides, but the issue here is that when FERC reaches a conclusion of this type, they have to do so by making a reasoned connection between facts and conclusions. And this actually gets me to my second point, which is that specifically in these types of cases, the Commission was required under Washington Gas to make two specific types of factual inquiries. The first being an inquiry into the company's capital costs and the potential investment returns in comparable sectors that would actually go to the financial integrity implications of the rate order. And the second thing that the Commission was required to inquire into was whether or not the investors had already been compensated for the risk of environmental liability, as was seen here. And
is there anything in the record, though, that answers that question? Because I didn't see it, but I may have missed it, that FERC said that if we require the provider of the services to bear this whole cost, they can't stay in business. Or, I mean, your position, do you have evidence in the record to suggest they can withstand it, just meaning their shareholders may get a little less?
Your Honor, the key issue is that there isn't such an indication in the record.
Is not, okay.
That's right, Your Honor. Under Washington Gas, the Commission was required to inquire and not just take the company's words at face value into its capital costs and the implications for whether it could pay debt service, whether it could issue comparable dividends, and importantly, whether or not the returns from other sectors that might compete for capital dollars.
What did your client offer on that?
Mm-hmm.
I'm sorry, Your Honor?
What did your client offer? Did you do anything to counter what the utility offered as the cost?
Your Honor,
or what its revenues were or anything else?
Your Honor, SCRAP isn't in the position to have that sort of information. And this court's APA cases have said that the onus is on the agency to make that type of inquiry because SCRAP is an intervener here. There aren't interveners in necessarily every such rate-making proceeding. And so the agency is required under Washington Gas to make those types of inquiries, which they did not do here.
Well, and I'm sorry, Judge, go ahead.
You're saying there are no devices available to you to make inquiry of the utility in this instance of those types of very relevant and germane financial considerations.
Your Honor, our position is that the onus is on the agency to
are there devices for you to gather that information?
There may be some type of discovery instrument that's available in certain cases.
Investigate those.
Your Honor, the record doesn't reflect whether or not SCRAP requested subpoenas or anything of that type.
But it reflects that you didn't offer any evidence.
That's my understanding, Your Honor, because SCRAP was not in a position to have that type of information.
You mentioned, counsel, the onus being on FERC, but I mean, they found that the earnings would be reduced by over 66% if the full cost was to be borne by ComGen. And I don't want to speak or presume to speak on behalf of my colleagues here, but I feel much more comfortable allowing FERC and the expertise they have to look at that financial information as opposed to someone like me who can barely add. That's why I went to law school. So I guess my question again comes back to where we started with, is the finding about the potential financial impact sufficient under the substantial evidence standard to affirm what FERC said? I realize they did you a big favor, right? They included some things in their findings that arguably had nothing to do with their ultimate conclusion, and enabled you to make the argument that you're making today. But at the end of the day, if that's not in there, if those findings about what ComGen did negligently and the seal being improperly installed, if they simply find a reduction like they did of over 60-some% in earnings. Is that enough to justify that rate increase?
It is not enough, Your Honor, under Washington Gas. And Washington Gas is, I think, a helpful precedent in this case because the facts are very similar on that issue. In that case, the utility made a representation through testimony to the commission that a rate of under 4% would not be enough to maintain its financial integrity. And the commission accepted that on face value. And what this court said was, quote, commission expertise alone cannot support so pivotal an assumption. And that's at page 17 and 18 of Washington Gas. What's important to inquire into, in addition to just taking at face value the company's representations, is its actual capital costs. And those include the company's debt service, those include stock dividends and returns on investment in comparable sectors. The second inquiry is also important because in this case, it's unclear from the record whether or not ComGen and its investors had already been compensated for the type of risks of environmental liability that we see here. So while the record is absent, there's some indication that the investors had actually been compensated for that previously. At the time
Does the record address whether ComGen put on any evidence before the commission as to how they would be affected?
The record suggests that ComGen made a representation through testimony to the commission that its financial integrity would be threatened, that it would have difficulty raising capital in the markets. But the record doesn't suggest that the commission actually made an inquiry into things like the dividend, the historic dividends paid to its investors, the cost of its debt service, and importantly, the expected returns on investments in comparable industries.
Well, could they read into that financial integrity that they'd be put out of business?
Your Honor, what Washington Gas suggests is that the representation by the company and even the commission's expertise itself is not enough to sustain that finding, that there needs to be more.
What about the constitutional issue that was raised in the unconstitutional taking? Would this not be a violation of the takings clause?
In Jersey Central, this court said that a company of this type does not have a constitutional right to a profit, and what's required under the Supreme Court's precedent in Hope is that when deciding a takings question in this type of context, the commission has to balance the financial integrity of the company against the interests of the ratepayers. And what the commission here did not do was adequately consider the interests of the ratepayers.
But if we accept what you're asking us to do, counsel, we know that ComGen is going to have much less of what I'm going to refer to loosely as a profit than what FERC has already decided it should have and what's reasonable given all of the relevant factors. Well, how can that not be a taking when we compare that to the $3.30, I think approximately, that the ratepayer is going to incur over the course of the 10-year time period?
I see my time's expired. May I briefly answer and then conclude?
Yes, please.
So the key question here is whether or not passing along cost to ratepayers would be exploitative. That's what this court held in Jersey Central. And the Supreme Court held in NAACP versus the Federal Power Commission that unnecessary costs can never be just and reasonable under the FPA, regardless of the outcome for the company's financial integrity. And for these reasons, we respectfully ask that you remand the FERC's order to the commission for a rehearing.
Thank you.
Thank you. Thanks.
May it please the court. To find liability under the Clean Water Act, the opposing counsel must overcome 3 presumptions to prove the hydrological connection theory is valid, and they have not done so. Number 1 is the text. The definition of navigable waters does not refer to groundwaters or even hydrologically connected groundwaters. Number 2, the legislative history. Congress had proposals before it in both houses to regulate groundwater out of this exact environmental concern, that groundwater could lead to pollution of navigable waters. Congress voted down those proposals, showing at least strong evidence that Congress did not intend to regulate hydrologically connected groundwater, despite the fact that it was aware of the environmental concerns. And third, the constitutional avoidance canon. As the Supreme Court held as binding precedent in Swank, there must be a clear statement to overcome the traditional presumption that the states retain control over their traditional and primary power over land and water use. As here, Scrap has not demonstrated that it can overcome those three presumptions, and therefore, the text of the Clean Water Act does not support the theory of liability.
Mr. Barsky, that's impressive, but you're leaving them without a remedy, and you're leaving people who are stuck with water that's been polluted by your client. And so what is the remedy? None? You have all these congressional niceties, and you leave this big hole. They have nothing. Doesn't seem right.
I think that's incorrect, Your Honor, for two reasons. First, as I noted in my earlier argument, there are a number of statutes that regulate similar types of pollution, including—
Tell me one that would have given them a remedy.
Including RCRA, which addresses specifically contamination of ground and surface waters through leachates, the exact sort of pollution available
They have ordered
here.
them to remedy this then, correct? Dig it up, make it right, and then do something with FERC?
Respectfully, RCRA could lead to remediation, and we believe that is sufficient.
Is there a case, any court case where they've done it?
The Fourth and Sixth Circuits were looking at coal ash impoundments and believed that RCRA had remedies for those sorts of pollutions. The Sixth Circuit remanded to reconsider the RCRA claim because it was improperly dismissed. Thank you, Your Honors.
Your Honors, two brief points on rebuttal about the Clean Water Act issues. First, on the Supreme Court's interpretation of the Clean Water Act, and second, on the Clean Water Act's text. On the Supreme Court interpretation, my opposing counsel referenced a potential constitutional avoidance issue here based on the Supreme Court case Swank, but that case was concerned about expanding the category of waters of the United States, a federal jurisdictional category that could impose Commerce Clause issues. But in this case, we already have pollution of a federal water, the Fish Creek and the Vandalia River. So we're simply asking this court not to read in a new requirement of direct discharge, which, as Justice Scalia's plurality opinion in a more recent Supreme Court case, Rapanos versus United States, recognized that that would be distorting the text of the statute to impose that directness requirement that doesn't exist. And so a second point on the text itself, you've also heard opposing counsel refer to a different section of the Clean Water Act that uses the word into, and opposing counsel suggested that that word somehow imposes a directness requirement, and the Sixth Circuit tried to use that reasoning, but that section of the Clean Water Act is about setting effluent limitations for the rates and quantities of pollutants, but the Clean Water Act is a strict liability statute, and the section about imposing that liability is where the statute says in section 1311 that it's only that to from pathway which is needed, which is exactly what we have here.
You mentioned the Sixth Circuit. They didn't try. They did use that reasoning, correct?
Yes, Your Honor, they did.
The Sixth Circuit, a better way to ask that probably is the Sixth Circuit disagreed with your position.
Yes, Your Honor, the Sixth Circuit did disagree with our position. But going back to some of the state regulation and cooperative federalism concerns that my opposing counsel raised, I think it's important to note that in that Sixth Circuit case, it was overturning a lower court, and it was using this reasoning of rejecting the hydrological connection theory. The state of Tennessee in that case actually submitted an amicus brief disagreeing with the appellate court's reasoning there and agreeing with the lower court that Clean Water Act liability should apply and that excavation of the coal ash impoundment would be an appropriate remedy. And this goes back, Justice Alloy, to your question about the remedies. It is correct to say, as opposing counsel did, that RCRA could provide for some form of remedies, but it could not provide for this closure by removal remedy because RCRA classifies coal ash as a non-hazardous waste. And moreover, while RCRA does cover solid waste like coal ash and imposes remedies and requirements for its storage, it doesn't impose the remedies we need for when there's discharge of arsenic leachate, which is what we have here. What Scrap is bringing this action about is not the storage of the coal ash itself. It's the very fact that the storage has failed and that we have discharge to the Fish Creek and Vandalia rivers. And for those reasons, we ask this court to affirm the district court's ruling and vacate FERC's order and send it back for a rehearing. Thank you.
Thank you, counsel.
Thank you.
All right, counsel, thank you for your argument. We'll be in recess. You all be seated, please. On behalf of the bench, I want to say what a pleasure it was for us to have the opportunity to judge this competition. I think at this time we are encouraged to give a critique, which is very, very difficult. We thought you all were absolutely excellent. This problem, when I began to prepare for it, I could not even keep the name straight. You all did it, and it just flowed, both sides. We are really proud of the jobs that you did. You not only answered our questions, but you were able to get back into your presentations very smoothly, and you mastered the case law, you mastered the record. It was just the type of judging jobs that we all wish we had on a daily basis that we don't have. And we want to congratulate you all on the absolutely wonderful job that you did. You should feel very proud of it, and if you have rubber arms, pat yourselves on the back. Judge Abelhausen.
All right, whoever came up with this topic and all of this scenario, let me just say, we're judges for a reason, because we couldn't handle the stress of practicing law, and therefore you need to dumb it down for us next year. I mean, you all did an amazing job. I mean, this really, it took me 2 times reading through it, and I still don't understand what we just did for the last hour and a half. But you all did an absolutely amazing job. I'm impressed with all of you that you could take, and not only that, the fact that you have to know both sides of this argument as well as you did, and you don't know which one you're presenting till you do it, to me is even more impressive, the fact that you all mastered this topic so well. That's going to serve you well in the real practice of law, but I don't think you'll have anything most likely this difficult ever in the history of humankind again. I would like for it next year to be like a environmental case, but let it be a criminal trial or something. Dumb it down, we can understand it.
Well, I echo those sentiments exactly. The only thing that I will say is that although I'd like to see you appear before me, the fact is that you are also good. It made our decision that much more difficult in choosing a winner.
It really did.
So the fact is that sometimes it's pretty clear cut who the winner is just by their ability to argue the case. And in this case, all I can say is that both of the teams are to be applauded for your performance here today. When I walked in this morning, I came a little bit early, and I ran into a fellow judge, and the first comment was, "This is pretty heady stuff." And then I'll talk about Judge Klee down here, and he came in and said, "This is pretty heady stuff." And this is on my second or third reading of it. So under the circumstances, I again commend you for the time and dedication that it took for you to prepare and to do such an excellent job of the presentation. And I don't know how you do that in addition to your regular studies, but I know that it's a sign of what your success in your careers will be in the future. And I thank you for the opportunity to sit up here and be able to judge you at this early stage of your careers.
First of all, on the problem, I would echo my 2 colleagues' observations. Problem was difficult, but it's supposed to be. And it was exceptionally well crafted after being rather studiously selected, because as you all know, part of this is now going to be in the breast of the Supreme Court very shortly. And that's not often that problems that are selected so quickly wind up in that forum. So compliments on selection of the problem. Well done. Very challenging. I want to tell you that on average I have 35 hearings a week. I've been on the bench about 4 years now. With the exception of one other competition of this type, I haven't seen the quality that you all displayed here today in your arguments, in your depth of thought and analysis. If I had the time, I could identify something that each one of you said, perhaps more than one on some of you, that just had not occurred to me until it issued forth from your mouth. So irrespective of the outcome, every single one of you have so much to be proud of. You represented your institutions very capably, exceptionally again. And the fact that you wound up in the finals with as many teams that are represented here and the quality of those teams just speaks volumes about your abilities. So, well done.
Yeah, I would echo my colleagues' comments on the problem and make a motion that it be dumbed down for the judges for next year. But again, I think that speaks to the testimony of work that you all put in and the job that you did. A lawyer I did a lot of work for in my prior job told me when I was a summer clerk that there are two parts to practicing law, and the first is the most important, and that is looking like you know what you're talking about, even if you don't. The second part is knowing what you're talking about. But he was very focused on the first part. But you guys obviously met both of his criteria. You did an excellent job. You got difficult questions from the bench, and you did a remarkable job of dealing with those, answering them, and coming back to where you are. And we all know how difficult that can be to get back to where you need to go. But your demeanor and your appearance before the bench was outstanding, and well beyond your years of experience, particularly based on what we unfortunately see sometimes in our respective courtrooms. But great job, everyone.
Well, it's always nice to be last because I can't agree with everything, and I've had the chance to do this before, but you all really should be just very proud of how well you performed. I can honestly say I haven't had anyone appear before me who presented any better. Never. And you should be proud of that. What the court expects, the court has to make hard decisions, and so your job is to help make that easier for them. And I have to tell you, there were times in your argument when I would listen, I thought, my God, you caused me to think about things in a way that I had not thought about. And that's what you want to do for a judge, and you have to think awful hard about that. And I appreciate you doing that. Sometimes you focus a little bit too much on winners and losers, and we're going to have to announce that. But in every case, there are two things that drive a case, facts and law. And in every case, that's something that you have no control over. So what your obligation is to present it in a way that the court can make its decisions. But boy, you just did it beautifully. You answered the questions. You answered the hard questions. One of the things that I'll say to both of you is that you get to advocate, but the court has to make a decision. So when I ask, I didn't want to, I would not have left this room without a remedy. Just wouldn't have had. Someone had to tell me there was one judge, they're just in the wrong place. And sometimes you have to think about those things because the court does have to make a decision. You have to live with them, and then we have to look into the future also. And so how this is going to affect other ones. And I have to tell you, I couldn't help but thinking, I'm a child of Appalachia. I played around these ponds. You know, it's a great place to play when you were a kid, right? And because it was always somewhere. And so we didn't think much about them. And they put them in places that were particularly not good. And yeah, it's had an impact on us. So people worry about those things. You worry about people who drink the water. You worry about people in the neighborhood as much as you worry about how do we approach this in a way that's balanced. I will say, Ms. Anderson, and I'm looking for the opportunity to use the frame arsenic leachate. Probably won't be at dinner, but I enjoyed it. But you all really, you had such confidence, poise, how you spoke, how you answered questions, just did everything right. We unfortunately have to announce a winner. But if we could have announced a tie, I wouldn't have been surprised about that either. So, thank you all.
Congratulations to you.
Congratulations.
We were
Can we
clapping
know
for
their
you.
teams? Can we know where they're from?
You'll hear it in just a second.
Okay.
Patience, Judge, patience.
All right, so we do have a wonderful sponsor for today's winner. It is Baps Callan, and with that, I would like to introduce Timothy Miller. He has been involved in more than 30 significant cases in this field, in this energy and environmental litigation. He mainly does complex litigation, including toxic torts and environmental cleanups. And he has also represented some utility companies, so similar to what you all had to deal with today. He's
also an excellent lawyer.
Yes.
And I have known Mr. Miller for years, and I referred to him as Judge when I came in, so no thanks necessary.
He is a shareholder with the Energy and Natural Resource and Litigation Groups with Babst Callen. He has litigated before the West Virginia Supreme Court and the Fourth Circuit. He is a graduate of WVU with a Bachelor of Science in Management and graduated from WVU Law. He was also the past president of the Energy and Mineral Law Foundation. So with that, I would like to introduce Mr. Timothy Miller, who will be presenting our awards.
May it please the court, I hate to turn my back on you.
That's right, that's right.
If I may do so. I have been told, I have been delegated the task of announcing the winners. And again, I concur with the remark about the tie. It would be fantastic. I have been the pleasure of being involved in this field for a long time. And I was involved in I think I was stimulated by a moot court competition to be a lawyer. And I thought it was the most fun I ever had in law school. We are always looking for opportunities as a firm to encourage young lawyers in these fields. We have a heavy emphasis in energy and environmental law. And I apologize for my bad cold. And we are a Pittsburgh-based law firm with D.C. offices in other states as well. But with that said, we are happy to provide a modest cash to defray some of the expenses for the team to be here. We will be sponsoring $1,000 cash prize to the winning team, along with a plaque. The Center for Sustainability and Energy is also sponsoring $500 to the second place team, as well as a plaque. And with that said, let me announce the winner of this year's competition is from the College of William and Mary. And the runner-up plaque will be awarded to a team from the Yale School of Law.
After this. Oh yes, first of all, there's pictures. As with all moot court competitions, you will be plastered everywhere. So Chelsea will be getting some pictures with the judges and the competitors for each team. And then after that, there will be a dean's reception in our event center. So you go out of here, turn right, and then it's immediately your next right. There'll be some food and drinks for everybody to enjoy. Thank you, guys.
Thank you.